morning.
Good morning, Mr. Chief Justice and other justices. May it please the court. My name is John Finn. Michael Finn is with me, and we represent Dr. Margot Roman, a veterinarian licensed to practice in Massachusetts who has integrated holistic and complementary care into her practice. This case is before you on an appeal from the allowance of the defendant's motion for summary judgment. The issues we have appealed relate to Dr. Roman's claim under the Massachusetts Civil Rights Act, the intentional infliction of emotional distress claim, and the negligence claim. I will focus, with the court's indulgence, on the Massachusetts Civil Rights Act claim. Initially, I just want to address the issue raised in this court's solicitation for amicus briefs. As I understand the question, it is to determine if First Amendment rights under the federal Constitution, including freedom of speech, which is the basis of our claim in this case, are in their essence inherently claims that require state action in order to exist, to be viable. In other words, are claims under the federal First Amendment claims that inherently and exclusively require governmental action. Applied to the Massachusetts Civil Rights Act, I think that the question posed leads to a following question, and that is, despite the legislature's decision in the Massachusetts Civil Rights Act to eliminate the state action requirement, is a claim such as this one for interference with freedom of speech, does such a claim nevertheless require proof of state action in order to be cognizable under the statute? Our position on that issue is no. Such a claim does not require state action. We look at the statute initially, and the statute, the legislature made it clear that state action is not a required element of the claim. We start with the statute. And also, much of our view on this finds support in Mr. Justice Bound's dissent in the Redgrave case, where he addressed this issue, didn't decide it, but addressed it.
But if it's constitutionally required,
yes,
then how can a statute alone eliminate or remove that one required element?
Okay, 2 points on that. With respect to freedom of speech and other freedoms in the First Amendment, as well as the freedom to be free from racial discrimination, within the federal constitutional context, all such claims, in order to be protected as a claim under the Constitution, require state action. It's one thing to say a claim on, if the Massachusetts Civil Rights Act had said that interference with rights protected under the federal or state constitution no longer requires state action, that would be one thing. It's a completely different thing to say what the legislature has said, which is that claims that rights secured under the federal or state constitution may not be interfered with an additional requirement under the state statute, and that is that the interference must be accomplished by threats, intimidation, or coercion. The state statute doesn't, the state statute refers to rights that are secured by the federal and state constitutions, meaning not necessarily protected but emanating from. And we're not confronted at this point with a statute that attempts to rewrite the law and say that a federal constitutional claim can be asserted under this statute when it couldn't be asserted under the federal constitution. I mean, it's not an attempt by the state legislature to override what has been a long tradition as a requirement of state action. The issue, though, is that if we look at First Amendment rights, and we look at other rights like those to be free from racial discrimination, under the federal constitution, they all require state action. All of them do. And to attempt to distinguish freedom of speech from those others as being less fundamental or less important for purposes of the requirement of state action even under the Massachusetts statute doesn't make any sense to me. I see no principled basis for doing that.
Now, if I can turn you a moment, why can't Tufts simply say, we don't want her on our campus? We don't like her.
Well, Tufts can, in certain circumstances, I think, do that. The factual circumstances of this case are that Tufts, which is an educational institution, which receives public funds, which speaks with authority with respect to the areas within its expertise, chose to present a lecture to the public at large without limitation and without restriction, advertised it as such. It was not a lecture that was going to provide academic credit to anybody who would.
Right, I understand that. So you're saying
So
that Tufts, that if Tufts says there are 12 people who are barred from our campus, if they have a public event open to the public, they can't bar them?
I think it would depend a little bit on what the basis for barring them was.
Well, here the basis for barring her from what they characterize as continuing education was because she hadn't paid her bill.
Well,
So let's imagine there was a student who didn't pay his bill and said, you can't come on our campus and enjoy the benefits even of any continuing education until you pay your tuition.
yes, but that would not apply to a situation such as the one we have here, where we have a lecture that is intended to be open to the public. It's not related to the teaching aspects of the school or the treating aspects of the school.
But they're they're a private educational institution. They can say, we don't want you on our property. It's private property.
Well, the fact that it's private property standing alone, I don't think answers the question. In this context, where the university has opened the doors of the public for a specific purpose, and a member of the public simply wishes to take advantage of the invitation and to do exactly what she was invited to do. In those circumstances, a decision by Tufts to exclude that person and that person only, based on that person's views with respect to the subject matter of the lecture, that's a very different situation.
So you don't factor in the fact that she owed the school money?
Our position on that, Your Honor, as we've indicated in the brief, is that I understand fully that Tufts' position is that the sole reason for the exclusion of Dr. Roman was that she didn't pay her bill. Our position on that is that the record contains sufficient factual information to support our position that that was a pretext, that the real reason was they disagreed with her views.
Do you dispute that she did owe money?
We do not dispute that there was a bill outstanding,
Okay.
and it has not been paid.
But your position is that was a pretext, and that the real reason for not allowing her to attend had to do more with the fact that she disagreed with the topic that was being discussed.
Yes, not more to do, Your Honor. Our position is that that was the reason for the exclusion, and that the record indicates, the factual record with respect to an incident in January of 2004 contains substantial information reflecting an animus toward Dr. Roman and her views regarding veterinary care. There's little doubt that there was animosity there and disagreement there. The university understood going in, when it opened its doors to the public at large to present this lecture, that the lecture involved a controversial subject. The university decided to present the lecture, as I said 4 times now, to invite everyone in the public without restriction or charge or anything else, but to also include a question and answer period. Now, hope springs eternal, and Tufts could have hoped that it would have been preaching to the choir, and that the only questions that were asked were questions by persons who agreed entirely with what the lecturer had to say. But there is no way to say that they could have reasonably expected that to be the case. They opened the doors to the public for a lecture on a controversial subject, included a question and answer period, knew that Dr. Roman was in favor of the feeding of raw diets to pets, and excluded her exclusively.
May I ask you two questions? One is, would a private institution have the right to just say, we don't want someone who disagrees with our position to attend an event? First question. Second question is, would you take the position that she had a right to state her views at this public event? Because if they had a question and answer, there's no guarantee she would have been called on to pose a question.
Yes. Answering the second question first, Your Honor, our claim is solely and exclusively that she was prevented from doing what she was invited to do, which is to attend and to participate if given the opportunity. We do not make the claim in this case that Dr. Roman went there to wrest control of the lecture from anyone or to do anything that would have interfered with what Tufts intended to do from the very beginning. So we do not argue that if she were not called on, she would have had a free speech right to stand up and say, I am taking over, I want to speak, I want to say what I want to say because I haven't been called on and I'm going to do it anyway. That is not our position in the case, Your Honor. Our position in the case is that when a private institution of higher learning decides to present this sort of a lecture on this sort of a subject that involves the dangers of risk to human health, Dr. Roman had a right to attend that lecture for the purposes for which she was invited.
Could I just go back to what you just said and what you began with? And for the moment, assume that we agree with your premise. What I'm interested in is you've said this Tufts has public funding. You've said that it speaks on topics in which it's got expertise. You've mentioned that this was controversial. You've said that it was open to the public. No funds were asked. There was Q&A. And you've said some other things.
Yes.
Which of those things would be proper considerations if we were to incorporate this as a claim that is viable? And which are not? Which are just for us to pull us in and be interested, and which are germane?
If I understand your question, Madam Justice, and I want to be sure I do understand it, if you were to conclude that the MCRA applies in respect to freedom of speech, either under the state or federal constitution.
To whom does it apply? You said higher
private
education.
property owners.
Pardon me? Go ahead.
I apologize.
I'll let you answer.
If what you're asking me is which of those factors that I've mentioned are the most crucial?
No, which are the factors? To whom would this apply? What is the field of individuals and entities to whom?
How far does this go into the public? How deep does this go into the public?
Exactly.
Into the private action? The answer is that the MCRA doesn't. The MCRA makes it crystal clear that private conduct that was otherwise not actionable is now actionable, provided it occur in the context of threats, intimidation, or coercion. I don't know how far it goes. I can safely say that if there is a corporation that is engaged in some sort of activity, some sort of business, and it invites the public in, and it's a business that involves politics or something else, and it invites the public in to attend a lecture on the subject matter of its government contracts, and if the but does not have a Q&A session. Inviting the public, I believe, gives rise to a right for the public to attend according to the invitation.
You're factoring in, it seems to me, and I'm not sure in your basic premise that that's legitimate to do, things like public interest topics that have to do with things like politics or wide interest of important issues.
Right.
So they have to be, I don't know how we do that. It only is big institutions that are having public lectures. This is the big institution exception, or, right? The big institution public lectures.
It actually isn't, Your Honor. The critical factor is whether or not the private party the scope of the invitation that the private party has made to the public.
Okay.
It's the scope of the invitation.
It can be an individual, it can be an entity. It's the
Yes.
scope of the invitation, no matter what the topic is or where. My home.
I don't think the topic is going to be determinative. The crucial issue, the necessary element, the thing that must be examined is the scope of the invitation that that private party chose to make. Now, the private party retains the right to decide how broad the audience is going to be or how narrow the audience is going to be, and it can do it in its invitation. But when you make the invitation to the public at large without limit, you have made it so. And having done that, you must permit the public, as invited, to do what it was invited to do. Nothing more. Nothing more. And if you want to limit the public's involvement by not having a Q&A, then you just go ahead and limit it. This isn't, this is not a situation like of competing First Amendment rights as depicted in Redgrave. This does not require Tufts to invite the public. It does not require Tufts to bring the public onto its property.
Mr. Fenn, your time is up. Thank you.
Good morning. There are three powerful reasons why this court should affirm the dismissal of the free speech claim in this case. Number one, there is no authority for the claim that there's a constitutionally secured right to receive information on private property that is enforceable against a private actor under the Massachusetts Civil Rights Act. Number two, the only free speech claim that's alive on appeal, which is the alleged right to receive information as opposed to the alleged right to convey it, was waived by reason of the fact that it was not presented to the trial court. Number three, a free speech claim of this kind necessarily depends upon evidence that the alleged restriction was content-based, and there is no evidence offered to the trial court to overcome the testimony from Tufts that its decision to bar Dr. Roman from this lecture was viewpoint neutral. So for all three of those reasons, the court should affirm the judgment dismissing the free speech claim.
Now you've not mentioned anything to do with state action.
Well, the state action has to do with the whole question of whether or not a right to receive information is enforceable against a private actor. And the claim that we have here is novel with respect to the state action dimension in two different senses. First, this court has never held that there's a right of action under the Massachusetts Civil Rights Act against a private actor for interfering with rights to speak that might be protected against government under the First Amendment or Article 16.
So if, for instance, the speaker at Tufts had been promised a certain amount of stipend, whatever, to make this speech, and if a person went up to this speaker just before they walked out on stage and said, if you walk out on stage, I am going to beat you, and he pulled out a knife and threatened the speaker with a knife. The speaker decided not to go out on stage for fear of bodily injury or possibly even death. Would the speaker then have a claim against the person who assaulted him under the MCRA based on deprivation of free speech?
It's a really interesting question. Clearly in that context where there's a threat of violence, that claim resonates in a way under the MCRA that the claim in this case does not. The MCRA was enacted in response to racial violence, and that is clearly the predicate for the statute. If there were a threat of physical violence that caused a speaker to decline to speak, that might be actionable. Where we have a situation like this, where the university has put on a lecture, and the claim is made that there's a constitutional right to come and receive the information that's being given by the lecturer. In order to recognize that right, this court would have to find two things it's never found. First, that the interests that Tufts has as a private property owner and as a exponent of ideas can be overcome by the claim that is alleged here by a private person to come to the lecture. And secondly, that there's a constitutionally protected right to receive information that's protectable against private interest. And there's never been a case that we've been able to find where the alleged right to hear has involved a private restriction on speech as opposed to a government restriction on speech.
But you're combining a number of things together, so let me see if I can deconstruct them. I asked Mr. Finn earlier, is it your view that Tufts has the ability to deny entry onto its property of any person it wants to?
Yeah, for any reason that's not otherwise unlawful, for example, racially motivated or gender-based or things of that kind.
So
it's a private property owner.
Your view is that we win on that ground alone. We don't even need to reach the constitutional issues. They can just keep her out because they don't like her.
They can certainly keep her out for the reasons that they did keep her out, which was non-payment of a bill. That's a legitimate, viewpoint-neutral, not invidious justification for keeping her out.
Would it be invidious if they kept her out because they feared that she may ask a question which they did not want asked?
Our position is that Tufts does not have a constitutional obligation to let somebody come onto its property to say things that Tufts does not agree with.
And could they bar her from that for fear that she would ask that question?
They could bar her if they chose to do it on that basis without violating her rights under the Constitution as enforceable under the MCRA.
So just to chime in for a moment then. So let's assume that we rule in your favor on this case. And down the road, she pays the amount of money she owes and you have another lecture. And she shows up there. Would you say, can't come in because we don't want you saying things we don't agree with?
The question is, could Tufts do that without violating the MCRA? We would take the position that it could. Tufts would not do something of that kind, and indeed made it plain to Dr. Roman that if she paid her bill, there would be no restrictions on her ability to participate in campus affairs.
Let me just get back to one aspect of Justice Gantz's last question to you. Would Tufts's exclusion of the plaintiff from attending the lecture because it didn't want to hear what she might have wanted to say, is that based upon on Tufts's First Amendment right, or is there a different basis for it?
There are really two countervailing rights here. One is Tufts' own expressional interests that are akin to those recognized for the BSO in the Redgrave case, and secondly, the property rights of Tufts that are implicated here. So you've got two countervailing rights that are rooted in the Constitution that stand opposed to a statutory claim under the MCRA that's asserted by Dr. Roman. And I think that Redgrave can best be understood, the dueling rights issue that's presented in Redgrave, which is also presented here, as a conflict between the constitutional rights of in this case, of Tufts as landowner and Tufts as university. Those are constitutionally rooted rights which are in conflict with alleged or claimed rights under the MCRA, and the Constitution trumps the statute, and so the duel between the alleged constitutional rights of the would-be attender of the lecture and Tufts, on the other hand, is resolved in favor of Tufts. And that's what Mitch Kaplan did below, and that's the ruling that we're asking you to affirm. So we are dealing here, and I just want to emphasize this point, that Dr. Roman comes before the court making a claim that in two ways is novel. It is novel in the sense that she's claiming a right to assert free speech claims against a private actor acting on private property under the MCRA, and this court has never recognized that such a right exists under the statute. And it is novel in the second sense that she's asserting a right to receive information as opposed to a right to convey information. And the First Amendment jurisprudence with respect to the right to receive information is quite limited, and there's no authority for a claim of a right to receive information being made against a private actor.
Okay, well, let me follow on that, because I've got some concerns about that. Let's take Justice Spina's example and turn it around. Let's assume that this person making the threat is going to say, I'm not going to interfere with the speaker speaking, but I'm going to say that I'm going to threaten anybody who attends that. Indeed, I'm going to basically do a bomb threat to prevent people from listening. So this person can speak, but I'm going to seek to intimidate anybody from attending.
And I
Would
guess
that not be a violation, even though it's not affecting the ability of the speaker to speak?
I think the difference between those kinds of cases and the case that we actually have here is that the threatener in the hypothetical that you've posed has no constitutionally rooted justification for the position that they're taking. And so we don't have the kind of tension that Judge Coffin spoke to when he wrote the Redgrave opinion, where we've got an issue of, you ordinarily conceive of the First Amendment as a restriction on government action, and he talks about how in transforming the MCRA into a statute that would convey rights to enforce free expression, the analogy with racial violence doesn't hold, because in asserting a claim like that against a private actor, the private actor isn't bound by the constitutional principles of a level playing field, neutrality in the marketplace of ideas, but in fact is permitted to take a position in the marketplace of ideas. Here, the person that you've posited has no legitimate justification, no property right, no expressional right that's being asserted through the threats and intimidation that they're visiting upon the speaker or the members of the audience. And so in that kind of case, one can imagine the MCRA being interpreted to provide a right of action. Whereas in our case, where Tufts is asserting its own rights as a property owner, which are legitimate and protected by the Constitution, and its own right as a mediating educational institution, which are understood to be protected by the Constitution, we have a very different state of affairs.
I'm sorry.
No, go ahead. So the threat of arrest in this case does not qualify for evidentiary purposes as a threat, intimidation, or whatever.
It may under the Batchelder case. That's not an argument that I'm here to argue as decisive of the case today. The arguments that we're making on appeal as decisive of the free speech rights are the three I mentioned at the beginning. Number one, that there is no authority for the proposition that there's a constitutionally secured right enforceable under the MCRA against a private actor on private property that interferes with an alleged right to receive information. But we also have in this case non-constitutional bases that would properly allow the court to avoid delving into these novel and difficult and challenging constitutional issues that have been raised on appeal. It's important to understand that below, the plaintiff only asserted a right to speak. She did not argue to the trial court that she had a right to receive information. On appeal, the table has been completely turned. She's reconceived of her claim as only a right to receive information and not a right to speak. And the reason for that tactical decision is clearly to avoid the import of the Redgrave case. And we see that most clearly in the ACLU amicus brief. And in fact, both Dr. Roman and the ACLU suggest to the court that the trial judge completely overlooked and misapprehended the essence of her constitutional claim. But what this court needs to understand is that the constitutional claim that's argued today was never presented to the trial judge. It's not in the summary judgment papers. In fact, Dr. Roman, after argument below, asked the trial judge for leave to file a post-hearing brief telling the trial judge that the denial of the ability to receive speech was not addressed by either party in the motion papers. Judge Kaplan denied the motion, and on appeal, there's no argument made that the denial of leave to submit a supplemental brief was an abuse of discretion. And so here we have a situation in which a non-jurisdictional claim has been waived by reason of not being argued to the trial judge, and that should lead the court, we would respectfully suggest, to affirm the judgment without addressing the constitutional point. But there's another reason why you can do that as well, which has to do with the question of pretext and viewpoint neutrality. There can be no doubt that Dr. Roman's free speech claim that she was unlawfully denied an opportunity to attend the lecture at Tufts must fail under any theory if Tufts' decision to exclude her was viewpoint neutral. There was no finding below with respect to pretext. Judge Kaplan simply assumed for purposes of his decision that the stated reason by Tufts was pretextual. Remember that Tufts' decision was based, according to its testimony, on the fact that she, as a former colleague at the veterinary school at Tufts, had refused to pay a bill for $1,000 based on an alleged claim of malpractice with respect to the treatment of her horse, which admittedly arose, according to her own testimony, from a reasonable difference in professional opinion. That's what actually went on here.
But you're saying that we should go back to the summary judgment record that Judge Kaplan reviewed, and even though he did not reach the issue, we should reach it.
It's all of that material is in the record on appeal. This court has held that it can affirm a grant of summary judgment on grounds not reached by the trial court judge. And we're asking you, as an alternative basis for finding that the judgment should be affirmed, to rule that the evidence that Dr. Roman mustered at the trial court level on the issue of pretext was inadequate to meet her burden of production under the applicable rules established by Matthews and the First Circuit cases that the court has endorsed in Matthews and the cases that follow Matthews.
If I could bring you back to an earlier point with regard to the educational institution, how does that cut? I mean, Tufts, I'm sure, receives federal and state monies. Would it be different if this was a Bank of America speaker series as opposed to a Tufts educational program open to the public?
Well, a couple of points. Although Tufts does receive state and federal funding, there's no basis in this case for a claim that it has such a symbiotic relationship with government that it is, in fact, a state actor. So we reject that. And I think that the way I'd answer your question, Justice Gantz, is that neither Mr. Finn today nor the ACLU in its amicus brief proposes that there be any limit to the doctrine that they're asking you to endorse. The ACLU actually asks you to hold that an MCRA claim will lie whenever the right to be free from content-based speech restrictions is violated by threats, intimidation, or coercion, even if the conduct is entirely private. Entirely private. So the proposition that's actually being advanced on appeal here knows no bounds, Justice Duffley, no bounds whatsoever. If it reaches Tufts, it reaches inside individual homeowners' homes. It is a remarkable, unlimited proposition. It is one that this court does not need to reach. It was waived below. There is no evidence that the restrictions by Tufts were viewpoint-based, and we ask you to affirm the judgment.
Thank you, counsel.
All right. Hear ye,